Hoffman Middle School. Is that right?
Yes, yes, sir.
And you had his height and weight, correct?
Yes, sir.
5'11" and 158 pounds.
Yes, sir.
You got that from the autopsy report?
Yes, sir.
Judge, if I can have just a moment.
Yes, you may.
You were asked questions about basic certifications for various weapons, right?
Yes, sir.
And you're aware that the defendant had a concealed weapons permit?
Yes, sir.
So he would have taken a course for that?
Yes, sir.
Isn't a person who is licensed to carry a concealed firearm supposed to disclose that to the police when they talk to him?
There's no law about it.
Aren't they advised to do that? When you speak to law enforcement, you advise them that you're armed?
You mean in person?
I mean over the phone, in person, at all?
Not over the phone. Whenever you interact with a police officer, if you're carrying a concealed weapon, obviously, traffic stop, interaction on the street, something to that effect, we tell everyone that when you interact with law enforcement, the first thing you want to do is make sure your hands are clearly visible and just let them know that you have a concealed weapons permit and you are carrying a firearm. We don't really ever address something over the phone. I mean, sure, I guess it would be nice, but you don't address it.
Well, to be clear, the defendant did not advise the dispatcher that he was carrying a firearm.
No.
And you said that you have a criminal justice degree, correct?
Yes, sir.
Were you taught the law of self-defense in any of those courses?
I've taught a lot of laws, yes, sir. I'm sure we covered that.
Were you taught fact scenarios that constituted self-defense?
I can't say that we were caught fact scenarios. Every instructor that's responsible for relating information relates it differently in every class. I can't speak to how everybody does it. I know how I relate the information, but I can't speak to how everybody else does.
And it was your opinion that a weapon was not used on the defendant?
I didn't see. Are you talking about Mr. Zimmerman? There was no weapon used on Mr. Zimmerman by Mr. Martin?
I believe that's what you said.
Yes. I didn't see any indication that a weapon of any type was used on him.
Right. You did see an indication that a weapon was used on Trayvon Martin?
Did I see?
Did you see an indication that a weapon was
Of course,
used on Trayvon Martin?
He was shot, yes, sir.
You know, have just a moment.
Yes, you may.
All right. Mr. Root, in listening to the non-emergency call and your conversation with the defendant, he told you he was following Trayvon Martin.
I think the term that he used was trailing, which to me, it means following. I mean, it's the same thing.
Okay. I mean, do you remember when Sean Nofke, the dispatcher, asked him, are you following him? And the defendant said,
Oh, yes, sir. Absolutely. In the 911 call, absolutely. He asked him, are you following him? He said, we don't need you to do that.
Did you read the defendant's written statement?
I'm sure I would have.
It
I
was
can't
about
recall.
4 pages handwritten.
I am confident I did. I just don't recall exactly what he had written. I mean, if you ask me a question about it, if I don't know, I'll honestly tell you.
Okay.
I've read so many of the documents.
I understand. Do you recall the term that the defendant used to refer to Trayvon Martin in that written statement?
No, that I honestly, I don't recall the term that.
You don't recall the term suspect?
Okay. I don't directly recall it, but I would take your word that he wrote suspect there.
All right. You would agree with me that that's a police term, right?
Oh, sure. It's a term that it's also a crime prevention term also. It's anybody that you interact with. they utilize the same verbiage, even though you may not get it. It most certainly, it's like saying civilian, and I get yelled at by a friend of mine because it's individual. But in law enforcement term, every individual is a civilian. So for suspect, we refer to as being the other person, the bad guy.
Judge, that's all I have. Thank you.
A big old piece of concrete, a weapon, if I hit you on the head with it?
If you hit me in the head with concrete, yes, I would.
How about if I
consider
just
that.
took your head and smashed it onto concrete? May I use the doll for a moment? Of course. Let's just use this for a moment because I want to follow up on some of Mr. Guy's questions. So, George Zimmerman, Trayvon Martin. Were the injuries on Mr. Zimmerman's back of his head consistent with someone doing this on cement?
I don't think so.
How about this? How about somebody resisting the attempt? The injuries, the 2 lacerations, could that have come from cement? If somebody was resisting me pushing down like this?
I believe so. I believe it was a culmination of downward force, whether it was from pushing or striking, and I know clearly by the injuries to his face, and that would drive him back, his head striking hard into the concrete.
Would you expect, based upon your training and experience, that somebody getting their head struck on the cement would attempt to resist it happening?
Of course, they would. Normal human instinct would try to move away from the pain stimulus, which would just create another gap to be driven back.
And would that occur not only the first time, but every subsequent time?
Whether it's a push or a strike, every time you drive a strike or push straight downward, the body goes until it hits an object that'll stop it.
Did you see the pictures of the injuries that showed punctate bruising and lacerations on the side of Mrs. Zimmerman's head?
Those were when I said blows raining down earlier, those were the things that really caught my eye, that supported the fact that it was a striking and not a pushing so much, because of all of the, lack of a better word, injury or damage that I saw on the side of the head. There's swelling all around his head. It's not just the facial area, it's all around the front.
Were those
portion
injuries
of his head.
consistent with somebody pushing a head down to the side? You see me move it to the side like that. Is that similar to that, hitting cement?
It could be. It could be that, or it could be punches as well, driving those strikes in.
And then on the other side, were the injuries consistent, hitting it down on the side, on the left side of Mr. Zimmerman?
It could be, and and just like Mr. Guy pointed out, if Mr. Zimmerman is on the bottom and he's not just laying there, he is moving, whether he's trying to defend himself, trying to do his sliding techniques or whatever they are, as he's turning his body or his head in those efforts, it's going to redirect and realign, so whatever push or punch comes in next, if he's turned this way, it's going to be a strike to a side, the front. That's all indicative of an ongoing combat event.
Now, talking about the angle, Mr. Guy, I think, was suggesting that we need to stay focused with the angle of entry of the wound being basically 90 degrees, so it's straight in, correct?
That's what he said, yes.
Now, that could happen, of course, as Mr. Guy suggested, maybe something like this, if Mrs. Trayvon Martin is trying to now back away at the end of the 45 seconds of screaming, correct?
Correct.
Do you agree that that's a possibility?
Absolutely, it's a possibility.
Do you have any evidence that beyond a reasonable doubt that is what happened?
No.
Could it happen this way?
Yes.
Same angle. Could it happen
Yes.
this way?
Yes.
Could it happen if Mr. Martin is reaching back with his hand for yet the final strike or something like that? Could it happen right there when he's coming back over?
As long as the alignments of the body stay within those same relative positions, where they are within that axis of movement, it's a possibility.
Now, you know that Mr. Zimmerman was, in fact, able to get his gun out of the right side hip, correct?
Yes.
Now, somehow he got to that, correct?
Correct.
How much weight do you give to Mr. Zimmerman's ability to disclose and to advise exactly how that happened?
Not a lot.
Why not?
Because when he became aware of the presence of the firearm, he reached for it. The transition under stress, the transition of how it got into the hand is kind of moot. And, my background, training, and experience, I've interviewed numerous police officers involved in shootings. And frequently I hear, I shot, well, when you draw, they're not clear on how they got into position. They just know they did it. Instinctually, survival mechanism, whatever it is, the point still remains, the gun was in his hand, and he did, in fact, discharge it.
And he discharged it in a way that was in contact with billowing clothing that was 2 to 4 inches away from his chest, correct?
Correct, which, when we think about the movements, if he's moving with I think it was an Arizona iced tea in his jacket, the hoodie, transitioning leaning forward, if that body position's there, that tea is going to keep it away as they transition back. If he's at some point leaning too far back or whatever, trying to get up, that tea is going to be pushing the shirt the opposite direction because it's going with the motion too. At what point and where they were, I can't specifically say.
Okay. In the context of your training experiences, the way combat events and how they occur, is it possible that at some point Mr. Martin was in fact up here?
There's no question that it's possible because during the event, when he says he's sliding down, I don't expect Mr. Martin to be able to match him move for move. Is it possible that at some point he was up on his chest? Yes.
Okay.
Then he slides
And
backwards.
is it possible that at some point he was here?
Sure.
And how about is it possible that at some point during that dynamic altercation he was even this far down?
It's possible.
When he's this far down, just over the thighs, where is that hip holster? I'm not going to ask you to get up. Just tell me when to stop my finger as to where the hip holster is.
Stop.
Right here.
Yes, sir. Right at the
Available
hip
to
line.
Mr. Zimmerman at that point.
Yes, sir.
Is it available to him at this point?
Yes, sir.
How about up here?
Yes, sir.
At this point, where you say it's available, what is my tie pointing down towards? Can you
His
see
belly
that?
button.
My tie is pointing directly to the belly button?
Yes, sir.
Based upon your training experience, was there just how much thrashing or movement was happening in that dynamic event between these two men at that point?
I would have to say a lot.
Was that evidenced by the contusions and abrasions on Mr. Zimmerman's head?
Yes, sir. In the clothing, showing the contact, the wet spots on the clothing. I think that you're not going to be involved in an encounter like this without it being dynamic.
Speaking of weapons and available, we had talked about mass approach the witness for a moment. Do you consider that this could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Most anything that you want to be a weapon could be a weapon, correct?
Yes, sir. I do training classes on improvised weapon systems. Anything can be utilized. Depends on how it's used.
You certainly agree that fists can be weapons, right?
Most definitely.
And you saw evidence of injuries caused by the weapon of a fist, right?
Yes.
And the weapon of concrete?
Yes, his head striking the concrete, yes.
And just so we're clear, did you see any evidence of any injury on Trayvon Martin from your review of the autopsy that was consistent with him being hit by this?
I didn't see anything to that effect, no, sir.
Did you see any evidence of any injuries of Trayvon Martin being hit by anything?
I didn't note any injuries on Trayvon Martin, except for there was the one point on his hand.
How do you explain that fact to this jury? How do you explain the fact that in an ongoing altercation, I'm going to presume for the point of this conversation that it was Mr. Zimmerman screaming, just for this.
Yes, sir.
And it was Mr. Zimmerman screaming 40 seconds. How do you explain to this jury that he couldn't even land a strike in defense of himself?
Well, if you...
Does that object to that? It's called for speculation.
Your Honor, I would have to-
You're asking for an explanation?
I am, and the door has, I think, been open as to potentialities of what happened between the two that night by Mr. Guy.
I'll overrule.
Can you restate the question again? I'm sorry.
Sure. Can you explain to the jury a couple of facts? I'm going to suggest that it was Mrs. Zimmerman screaming, and you've now testified that Mrs. Zimmerman was not able to strike nary a blow on Mr. Martin. Can you explain to the jury how that might have happened, how that occurred?
Well, if we were saying that he's the individual screaming, then we could conclude that with Mr. Martin on top of him, Mr. Martin was the aggressor, the strikes were being rained down, and he, for lack of better words, was physically incapable of responding, screaming for help, wanting somebody else to help him out of a very bad situation. And it's possible that his hands were busy. They were, maybe they were pushing. I wasn't there, so I can't say exactly what his hands were doing. But I know that if you're the aggressor in a fight, how can you be the aggressor and not hurt somebody? So in this situation, if he's the one screaming, the reason that there's an absence of injuries is because he wasn't the one throwing strikes.
Is it unusual for someone to simply be completely dominated by another one who is physically better abilitied?
It all goes back to mindset, and it's not unusual, but what really, you know, in listening to the non-emergency call that Mr. Zimmerman made, then it's clear during his conversation that he becomes concerned about Mr. Martin, especially when he's looking at him and walking back toward him, because he even vocalizes this to the dispatcher. He didn't get out of the car at that point to confront him. To me, my perspective is because Mr. Martin is not the I'm-in-your-face confrontational person. When he had the opportunity where he mentioned that Mr. Martin had taken off running, or I'm sorry, Mr. Zimmerman's not confrontational, when Mr. Martin had taken off, you know, and he announced that they took off running, if that's when he gets out and he, you know, is following, and the operator asks, "Are you following me?" He says, "Yes, I am." It's because there's no threat. He took off running. Everything about that one call that leads up indicates that he had concern about his safety. I can hear it in his voice. Then when he interacts with him and he's coming back and he's face-to-face with somebody, he's not confrontational. He's looking at me. He starts talking about trying, and you can hear it in the voice that he's talking to the dispatcher. And then when Mr. Martin's leaving again, suddenly his vernaculars strengthen, and he struck me as the type of person that doesn't have a problem telling you that somebody's a jerk, but he doesn't want to tell them that. So I actually lost the question. I'm sorry.
That's okay.
I
I'll
apologize.
refocus
I
it.
know I was going somewhere. I just don't
You
remember where
were.
it was.
I was just going to let you go, but we'll
Thanks.
refocus it. Let's start where I was going to.
Let me ask you a question. We have plans for the jury to go out for lunch, and it's going to take an extra long lunchtime. Is this a good breaking point?
It is, Your Honor. Thank you.
Thank you. Ladies and gentlemen, if you'll, as you're packing up your stuff, I'm going to remind you that you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to get on the internet to do an independent research about the case, people, places, things, or terminology. And finally, you're not to read or create any tweets, emails, text messages, or social networking pages about the case. I have your assurance that you'll abide by these instructions? Yes. Okay, with that, put your notepads down, follow Deputy Jarvis, enjoy your lunch. We'll be back at 1:45. Please be seated. Mr. Root, during the lunch hour, you're free to go about your own business, but you are not free to talk to anybody about your testimony. That includes the lawyers, okay? We'll see you back at 1:45. Is there anything we need to take up before we recess for lunch?
No, Your Honor, there are a few things that we have stipulations for entry, but I can do that at any point during my case. Maybe
Okay.
when we get back or afterwards.
That will work. Thank you. Court is in recess. Mr. O'Mara, did you want to take the moment to,
Yes. Moving into evidence, I believe there's no objection from the state. What is an affidavit and declaration of custodian of records from Sanford Police Department? Taking out the summary. This is my summary, but it's not an official record. I talked to Mr. Delarionda. I'd leave it in, but it's I created it.
Did he approve? Did he approve it?
No, I'm taking it out of the,
Oh.
yeah.
okay, so that declaration from the city of Sanford will come in without objection
Correct.
as Defense Exhibit 25?
Mr. Delarionda was who I spoke with, so I don't, Mr. Guy, and
Yeah, Judge, if we could just wait till he gets back, I think
Okay.
it's okay.
And then, well, what I also will announce, just so we're clear, and then Mr. Delarionda can finalize it, is
Here he is.
oh, great. Zeliando was just putting in the evidence or the exhibits we had talked about. I took off.
Yes, I apologize.
It's okay, I took off the summary, so that's not in it.
Right.
But
We
the
have,
rest
we have
is.
no objection to that, Your Honor.
Okay, and it'll come in as Defense Exhibit 25. What is the next one?
Next one, Your Honor, is the letter documenting that my client, from Florida Department of Agriculture and Consumer Services, documenting the existence of my client's concealed weapons permit and a very poor copy of it.
Any objections?
no objection.
That'll come in as Defendant's Exhibit 26.
And the last one is the the CD and the event report documenting the 6th of 6 calls that my client placed in the past 6 months before the event. The state had played 5, this is the last one. And
Any
We have no
objections?
objection to that either.
Okay, that'll come in as Defense Composite Exhibit 27.
I
That's
believe
it?
believe that's it, Your Honor.
Okay.
There was, and Your Honor, the layout that was presented, the state has no objection to it being entered.
Okay, and that would be Defense Exhibit 28. We could call that a still board of the crime scene.
Thank you.
Okay, do you want to look through your stuff and make sure you have it all?
Yeah, I think we do. There are a couple more we'll enter, but we'll do that just for the court's planning purposes. We have this witness, which we'll finish, then there are 2 very short witnesses.
Okay, Mr. Zimmerman, sir, did you have, I spoke with you this morning about your rights to testify if you want to, and the fact that you do not have to testify either. The jury cannot consider that in their deliberations of whether you testify or not. Did you have an opportunity to talk to your attorneys about whether or not you want to testify in this case? Do you need some more time to talk to your attorneys about that?
No, Your Honor.
Okay, and if you'll please just raise your right hand for one moment.
You solemnly swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, and Mr. Zimmerman, like I said before, you're aware that during this trial you have the absolute right to remain silent. You do not have to say anything, do anything, or prove anything. Is that correct?
Yes, Your Honor.
And you also have the right to testify if you want to. Do you understand that?
Yes, Your Honor.
And I've given you an opportunity to discuss with your attorneys whether or not you want to testify in this case, and you have indicated that you have had those discussions.
Yes, Your Honor.
And have you made a decision, sir, as to whether or not you want to testify
Your
in
Honor,
this case?
I object to that question.
Okay, overruled. Have you made a decision as to whether or not you want to testify in the case?
I object to that question. I think that's Mr.
Overruled. The court is entitled to inquire of Mr. Zimmerman's determination as to whether or not he wants to testify. Mr. Zimmerman, have you made a decision as to whether or not you want to testify in this case?
No, not at this time, Your Honor.
Okay, and when is it that how long do you think you need before you make that decision?
Your Honor, may we have an opportunity to speak? The case isn't concluded yet.
I understand that, and I've asked Mr. Zimmerman if he needed more time to talk to his attorneys, and if he does, I will afford it to him. Mr. Zimmerman, how much more time do you think you're going to need to discuss this with your attorneys?
I assume it would depend on how long the recesses are, Your Honor. At the end of the day,
Okay, well, if your attorneys have finished with 2 witnesses before the end of the day, do you think that you would then know whether or not you want to testify?
Your Honor, on Mr. Zimmerman's behalf, that
I am
decision...
asking your client questions. Please, Mr. West.
I object to the court inquiring of Mr. Zimmerman as to his decision about whether or not to testify.
Your objection is overruled. Mr. Zimmerman, I will give you more time, sir, to discuss this with your attorneys. Thank you very much.
Let me approach on an unrelated matter.
Yes, you may.
Good afternoon, sir. When we broke, I was just beginning to talk to you, and I wanted to go back to your cross-examination and a couple of questions that came to mind. You were asked by Mr. Guy whether or not you had listened to what we are calling the non-emergency call, which is the one in which Mrs. Zimmerman says words, some expletives. He says assholes and some other words. You remember having reviewed that?
Yes, sir.
And you were asked a question whether or not, in context of Mr. Zimmerman's presentation, if that evidenced to you some type of anger or frustration or whatever it was by Mrs. Zimmerman. Did you had an opportunity in your experience as law enforcement to hear people in angry, upset, and frustrated ways?
Yes, sir.
Have you actually been involved in situations where you had to try and break up disputes, be they domestic disputes or fights, where people are yelling and screaming at each other?
Yes, sir.
And has that been sort of throughout the entirety of your career?
Yes.
Is that just one thing that police officers do as a part of their job?
Yes, sir, it is.
Have you seen and heard people in various states or stages of anger and hatred and ill will as they're yelling at people or each other?
Yes.
Using that basis as an experience foundation for your testimony to this question, was any of that evidenced to you in the way Mr. Zimmerman said the words assholes?
The way I interpreted the way he said or used the verbiage that he used, it was more of a frustration about the totality of everyone he's called in on, or an element in and of itself, not specifically one particular person. My interpretation of the comments he made were, in general, that they always get away.
So in that word, assholes, did that evidence to you, based upon your experience, any level of ill will, hatred, or spite for Mr. Martin?
No.
There was another expletive that Mr. Guy questioned you about. Could you even hear the words effing punks when you listened to the tape?
Initially, no. That was something that you really had to try to break down and listen to.
At some point then, when you went back to listen to it enough to hear it, did there come a time when you ever go back and listen to it enough where you actually could hear the words?
Yes, the interpretation, but again, it was after being told they were there.
Similar question then, based upon your years of law enforcement experience, did those two words evidence to you any ill will, hatred, or spite that Mr. Zimmerman evidenced towards Trayvon Martin?
No, not individually.
And it was your understanding from your review of that telephone call that the frustration was aimed towards whom?
I would say
That is calling for speculation.
There were two questions that Mr. Guy asked you, and that was, one, about a responsible gun owner, and two, about other options that Mrs. Zimmerman may have had. So keeping those two questions from Mr. Guy in mind, was there anything in Mr. Zimmerman's use of his firearm that you would consider to be reckless?
no,
Why not?
because the use of the firearm was...
Yeah. Judge, I'm going to object as to the motion previously heard.
I might be heard on that. This question was,
Okay, well then approach.
yes. All right, continue.
Yes, you may.
Mr. Root, based upon your training and experience, was there anything in the way Mrs. Zimmerman handled his weapon that night that was dangerous? I mean, obviously danger whenever you shoot a weapon, but did he do it in a way that was unreasonably dangerous?
No.
Again, I'm going to object to the same objection as to our limiting motion.
Okay, overruled. Move on to your next question, please.
Yes, Your Honor. And I told you about two questions that you were asked. The other question was whether or not, in your opinion, based upon the facts and circumstances that existed at the time of the shot, whether or not Mrs. Zimmerman had any other options available to him.
Again, Judge, I'm going to object as calling for speculation.
Thank
I think he's already testified as to options as a response to a question from you, so overruled.
Well, Judge, and I would object to, again, the limiting motion and the content of his answer.
Overruled.
So, Mr. Root, based upon your training and experience, and knowing what you knew about the facts surrounding the event that night, particularly at the moment of the gunshot, did Mrs. Zimmerman have any other options?
Based on my knowledge and understanding of him, the environment, the situation, totality of everything, I don't believe he did.
There was inquiry as to whether or not you took this case on for the pure notoriety of it. I want to ask you some questions about that. Did you? Is that the main reason why you took on this case?
Absolutely not.
For whatever purposes, certainly with some of the benefit of having a high-profile case, does that or has that impacted in any way on any of the answers to your questions presented either by me in direct examination or in cross-examination?
No, because the same type of negative media coverage comes from this case as positive media coverage. Nothing had any influence on my answers other than my evaluation of the facts as I understand them from this case.
Does the possibility of some future payment to you from me for your testimony here today, did that impact at all on the way you presented your testimony?
Not at all.
The question was posed as to how many times you've testified as an expert. I think you said this is your first time testifying in a self-defense case?
In a criminal trial, yes, sir.
How many times have you testified in a criminal case?
Oh my, I couldn't quantify a lot. I mean, throughout a 22-year career in law enforcement, many times.
Okay. Have you ever been cross-examination by a prosecutor?
No.
Normally you are actually on the side of the state, correct?
Yes, this is a complete opposite of where I normally sit.
I want you to presume for a moment that you don't have any information about where the fight started. Forget the location of Mr. Zimmerman's little small flashlight or anything else like that. Focus for now just on the 40 seconds of screaming and the injuries. With that set of circumstances, would you change your opinion at all about Mrs. Zimmerman's lack of options?
No, I would not.
Would your opinion be the same even if there was 2-minute delay between the ending of Mrs. Zimmerman's phone call and the event that happened which caused those injuries?
No, that would be irrelevant to me.
What are the only real relevant factors that you look at when, in this case, when evaluating the use of force?
The primary elements that I look at are the event as it's unfolding at the moment that the use of force was taking place and the perception of the individual involved in the event itself. What did they perceive their position to be presented as? That's the ultimate thing that I have to look at when I look at a use of force case and come down to the nuts and bolts of things. It's at the moment the force was used, given everything else, at that moment, the perception of that person that was using force, what was their perception at that given second, and how would that affect the outcome?
Okay, we talked about the flashlight for a moment, the keychain flashlight. Did finding or noting that keychain being there, was that relevant at all in helping you determine where the altercation may have occurred or begun?
It helped create a picture in my mind as where it's possibly started at.
You were asked about blood flowing down or blood flowing back. In your experience, both from law enforcement and I guess more particularly from your experience as a, do we call you a fighter? Is that-
Sure.
Okay, as a fighter, what happens when you get hit in the nose?
Well, there's a variety of things that take place with a nose strike. I mean, there's one of the most immediate things, because of the nerve at the base of the nose with a nose strike, it can cause immediate tearing of the eyes. If the blow is significant enough and it does result in bleeding, there's a free flowing of blood, which, depending on the person, how it's flowing and so forth, it can fill the nasal cavity, drain out of the nose, but that can have an effect on your ability to breathe. Obviously, the most primary effect that it would have, in addition to injury, is the stunning effect that it can have on a person.
And in your experience with fighting MMA and other types, is getting in a blow like that early in a fight significant?
The training and everything behind it
Objection,
is,
Your Honor, it's calling for speculation.
Sustained.
If you were in a fight and want to get advantage over the other person, would a strike to the nose accomplish that?
Objection, no to relevance and speculation.
Could be heard, but I don't want to.
Pardon, well, I don't know if that's in his experience or not. So,
Let me do a foundation.
Thank you.
You've been a fighter, correct?
yes,
Just to remind the jury what we talked about this morning, you've actually done kickboxing.
yes,
Does kickboxing include kicking and boxing?
yes. Basically, it's boxing, and you have to have a minimum of 8 kicks per round to basically maintain the level of kickboxing, but it's using your feet and your hands.
Okay, and as part of using your hands, you strike body blows, correct?
Yes, punching
And do you ever try and hit somebody in the face?
repeatedly, yes.
Okay, is that sort of a target focus for you as a fighter to hit somebody in the face?
It is, especially with the jab.
Okay, and with that as an experience basis, how successful is getting in the first shot to the nose in a fight?
Getting the first shot into the face or into the person, it can provide a various outcome. The primary thing is you let the person know you're for real, and it's devastating, especially if you have a hard punch. You know, the rule of thumb for us in training and everything else is the fact that when a punch is thrown, if you're the recipient, and you take that punch, that first strike, which is generally speaking 100% of what the person has, because they don't try to just half hit you, you've taken a majority of their power, and if you survive the first punch, you can stay in the fight. For somebody that's not well schooled or doesn't have the same ability, it can have a devastating effect. So getting the first strike in and setting the tempo of the fight and letting the person know that you're on the attack and you're the person in control of the fight is very important, and especially in any combat type art, because he who controls the ebb and flow of the fight, the rhythm of the fight, generally can become victorious.
And you've seen this picture before, of course.
Yes, sir.
Is this consistent with a strike to the nose?
Yes, sir.
If this was the first strike of the fight, would it be, as you testified, a significant maneuver to control the ebb and flow of the fight?
Judge, that objective is calling for speculation.
Based upon his experience and training, Your Honor.
But you're showing him a picture of something else, so you need to ask a different question, rephrase it.
Yes, Your Honor. You talked about your criminal justice degree, correct? But you talked earlier about the police academy, and I want to see if there's any difference between the two. In your training, well, it's going to be difficult, but because you got your criminal justice degree after you started training as a law enforcement officer?
Oh, yes, I pursued my degree
Okay.
well into my career.
I'm going to try and separate the two. Did you learn any of your striking techniques or resistance techniques or takedown techniques in school for your criminal justice degree, or was just that in the academy and your further law enforcement training?
There was no physical courses like that required in my criminal justice degree. The criminal justice degree is geared toward more to educating you about the criminal justice system, about the courts, the processes, and things like that. The academy is about applying the enforcement of the laws. What laws are to be enforced, how to enforce them, physical ways to enforce it, how to conduct traffic stops, how to conduct everyday business as a professional law enforcement officer, whereas a criminal justice degree is kind of like the bookend, if you will, of criminal justice. It's how the system works in and of itself.
And having done it for now, I guess, 20, 25 years, did you enjoy being a law enforcement officer?
I did. I enjoyed being a police officer very much.
You think that it was, for you, a noble profession?
Absolutely.
Would you encourage or discourage, say you had a 20-year-old nephew or son, would you encourage them or discourage them from taking on a life of law enforcement?
Depends on the child. I have a stepson, for example, very physically fit, and I would encourage him without question to pursue it. My daughter, on the other hand, who doesn't like confrontation, who doesn't like that, I would not encourage that. But anybody who really wants to make a difference and is able to take on the stressors of that type of position, it's a very noble career, and I would recommend it to anybody.
You had mentioned early in the conversations about sort of the continuum of force, that a certain act can allow a response. So if you say to me, go over there and sit down, and I go, no, or even more colorful words, then you get to respond verbally. Is that sort of part of what we're talking about?
That's a piece of it, yes.
Okay. So, and that continuum of force sort of goes up the scale all the way and ends at deadly force, correct?
Yes.
Okay. And are there markers along the way that allows you to increase your response to force?
Absolutely.
So let's just say that I walked up to you and pushed you. What would an appropriate increase in force be based upon your training and experience?
I'm going to object as to relevance, as this relates only to police officers.
I'll broaden it. I want you to answer the question based upon your experience as an adult, based upon your experience as a fighter, and based upon your 20 years of law enforcement experience, and also based upon your expertise in looking at use of force events. So with that context, let me ask you a couple of questions about that. When you look at use of force events, does that go across the spectrum of use of force?
Yes.
Okay, we're not just talking about, you don't just specialize in use of force of deadly force, correct?
No, use of force is force, whether it starts from the very beginning, from verbal communications, and goes all the way up to and including deadly force. It's a very wide playing field.
So if you were aware of a situation, one of your, I don't know, cadets or one of your people that you would end up helping to train, where they were just using inappropriate verbal force, screaming too loud or doing whatever, would you then counsel those people? Maybe I'm not saying it right.
Yeah.
Let me try again. When you do your use of force training within your experience, both law enforcement and as a trainer, does that include training law enforcement officers and whoever wants to be trained as to how to use even verbal force, where you use the command voice?
All of our force training, whether it's law enforcement or for individuals, the idea behind any level of training related to force is to explain the variables involved in deciding how to apply force and what justifies it. If somebody's being verbal, obviously we would recommend to them that if possible, our number one recommendation for everybody, if confronted by an aggressor, is try to avoid it if you can. But it all depends on your environment, your ability, the ability to leave, the ability. Sometimes people don't give you the opportunity to leave. Sometimes they could be yelling at you from 40 feet away. So all of these variables come into play. So when you look at each event, you have to take into consideration all of these variables. So if I was yelling at you and cussing at you from 40 feet away, my recommendation for you would be just to, you've got 40 feet, walk away, clear the area. If I'm up in your personal space within 6 feet, 3 feet, within arm's length of you, and now I'm getting that same hostility and everything, and I'm very animated, now that verbal confrontation becomes a more significant issue for you because of the distance that we've closed. So really, it's very difficult to answer A and B because the totality of everything comes into play when you consider when and how force should be used.
Okay, so going back to my question I asked a moment ago, we were outside in the courthouse and I walked up to you and pushed you on the chest. What would your response be?
My
Objection, Your Honor, again, as to relevance and speculation.
That was where I laid the foundation, Your Honor, as training experience.
Overruled.
My personal response, if you shoved me, I mean, again, we're taking this just, you walked up blind and pushed me, I would take a position of advantage and give you strong verbal commands and make sure that it was very clear to you that you made a mistake.
Would you punch me in the nose?
Objection, Your Honor, as to relevance and speculation.
Again, his training and what level of response he would have.
But you're asking him what he would do in a situation just at that,
I'll move on, Your Honor.
sustained.
Move on. I might just have a moment. Thank you very much, Your Honor, for your question.
Recross?
Yes.
So your opinion that there was another option is based on the words from his mouth, right?
No, sir.
Did-
My opinion
Did you talk
that
to
he
somebody
didn't have
else?
any other
Sorry, Your
options,
You could be allowed to answer his question.
my opinion that there was no other options was based on the totality of his training background and experience. The options that you're referring to really come into play based on what you're capable of doing, not simply just because this event's happening, you have another option.
Don't the options also depend on what the other person is doing? In this case, Trayvon Martin?
Well, absolutely.
So your determination as to what Trayvon Martin was doing at the time he was shot came from him, right?
That was one of the elements that I considered for that. But when you take the small portion of weight given to a statement and then you add in the other evidence that surrounds the event, the injuries and everything, to see if it corroborates it to a point that it seems plausible that this exactly is what took place, and everything lines up to say, yes, based on what I see here physically, the injuries and so forth, this all makes sense. So the opinion is that based on what he told me in combination with all the other variables involved, that's how I formed my opinion.
Yes or no? Do you know what Trayvon Martin was doing at the moment he was shot?
Yes.
You do.
You're asking my opinion. Based on the information I was given the opportunity, just like I could look at you and say, I don't know what Mr. Zimmerman was doing, I don't know what Mr. Martin was doing. If you're looking for me to say that I don't know if Trayvon Martin was doing this one specific thing, we're talking about the totality of how I formed my opinion. What you're asking me about, what was he doing at that time? It appears clear through the evidence. If you want me to just surmise and say that, well, based on your perspective, he wasn't doing this or George Zimmerman wasn't doing that.
I don't want you to surmise anything. I asked you a very simple question. Do you know what Trayvon Martin was doing at the moment he was shot?
I personally was not there, so I cannot attest to specifically knowing exactly what Mr. Martin was doing at the time. I can only base my opinion on the totality of the evidence as I've learned it throughout my exploration of this case.
Which includes your perceptions, or his perceptions as he told them to you, right? Didn't you say the defendant's perception is important?
The perception of an individual involved in any conflict is what you have to take into consideration when making a forced decision. So the perceptions, if I told you I had a perception that the Jolly Green Giant was jumping on me, that would be ridiculous. But if I was in this booth right behind here and said I had the perception that one of these wires were wrapped around my ankle, it was plausible. The perception is taking in the totality of the event as it unfolded to see if the perception that was related by Mr. Zimmerman was plausible.
Right. The perception that was related by him.
Absolutely, yes, sir.
And your conversation with him came about 2 or 3 months before his second-degree murder trial, right?
Sure, that sounds about accurate, yes, sir.
You were asked about testifying. This isn't the only time you've ever worked in a criminal case, right, on behalf of a defendant, is it?
No, sir.
I mean, you've been consulted on plenty of cases on behalf of defendants, right?
You're going to have to qualify that a little bit more and say you have a bunch of cases on behalf of the defendant.
Right. Have you ever been retained, hired by a defense attorney to testify or consult with on behalf of a criminal defendant?
A criminal defendant, I believe, retained. It's in my curriculum vitae, so I don't want to misspeak this. Twice, maybe, I think. One would have been, I think, the Chambers case, and the other one would have been where I consulted, did not have to testify either by deposition or in trial. The name of the gentleman's escaping me, but it's toward the bottom of my CV.
This is just the first time you've testified in front of a jury.
Yes, in a criminal case in this way, it is the first time I've done this, yes.
And you mentioned the continuum of force, the force continuum, that applies to law enforcement officers, right?
The force continuum is a conceptual model. It's when you look at use of force, if you looked at Florida state statute, that's a continuum. It's a systematic approach to the escalation and de-escalation of force. The use of the words continuum came out of law enforcement, yes, but the actual application of the concept is regardless whether you're in law enforcement, you're in the military, or you're an individual on the streets of, Orlando. A continuum is still part of the conceptual variables that you consider when looking at a use of force event.
You were asked about getting punched in the nose. You don't know when George Zimmerman was punched in the nose during this confrontation, do you?
No, he was punched obviously repeatedly during the event. The exact time that the injuries to the nose were sustained, I couldn't tell exactly.
And it may have not have been from a punch even, right? Didn't you say earlier it could have been when he hit it on something else?
No, I never said that. I never said that George Zimmerman hit his face on anything else.
Could it have been caused by something other than a punch?
In this event, I'm not aware of anything else that was present to have resulted in that injury, so
Okay, you're not aware of the concrete?
I do not believe that a facial contact of that nature with concrete without seeing other types of abrasions to the face and the eye areas, because when you're talking about the force significant enough to cause that damage to his nose with an impact on a flat, hard surface, you're going to have continued rollover, which is going to increase injuries in some area around the face. And it was pretty clear that the abrasions around the eyes or anything like that, so I wouldn't recommend the position that concrete caused that nose thing.
Well, let me ask you this. You've been punched in the nose before, right, during a fight?
Absolutely.
You didn't quit, did you?
I didn't quit?
Right. Did you keep fighting?
No, I'm a fighter.
So you kept fighting?
Absolutely. If you're a fighter, that's the whole purpose of entering into a fight is you fight.
And you've seen other people continue to fight after they've been hit in the nose, right?
I have seen both. I've seen people that when they've been struck, it exits the fight right there. The fight continues, but they are not able to respond in any form or fashion. And then I've seen others. And I mentioned earlier about the warrior mindset. Not everybody has that. So when you look at an individual, if they're involved in a physical altercation and they don't have that internal fire to be involved in that way, they're not going to fight. And when the fight starts, they're going to be that person that's just beaten. Where conversely, if you have somebody that's got the warrior mindset and they're struck, they're going to return in like fashion, and then you have two individuals with the same mindset going about one another, and you have tremendous damage to both persons because neither one of them is going to stop.
All right. My question was, have you seen people who have been hit in the nose during a fight and they keep fighting?
Yes.
Okay. Mr. O'Mara got on the floor here, and I got on the floor, and we did this little demonstration, you kept using your hands like this, like, gotta be 90 degrees, right? The two bodies, isn't that what you did?
I was trying, considering you were on the floor with a mannequin, I was trying to use my hands as trying to best relate that I could, that just being in this position, when you talk about 90 degrees, we're talking about maintaining a level or an alignment in some ways that puts them in a position. So when you talk about leaning back, maybe Mr. Zimmerman's coming up, but when you had the mannequin in that position, you weren't maintaining that same alignment, so the 90 degrees that you were referring to wasn't possible from what I was seeing. So I was trying to visually use to show that, you notice when one hand turns, the other hand turns. At some point, they were in this alignment that enabled them to have that type of entry wound.
Okay, well, in fairness, haven't we left something out? That is like the wrist and the hand and the arm. Can't that move independent of the body?
Sure,
Right?
but what you're talking about there is you're now wanting to say that it's this. Is that what you're saying?
Well, I'm asking you, if I'm laying flat on my back and somebody's over me like this, can I not shoot him at 90 degrees even though I'm on my back?
Can
my
you?
arm-
Yes, but when you also look at it from the perspective of actual discharging a firearm, if you try to hold any firearm and then hold like this to shoot, it's going to become much more complex. The average person isn't sitting there trying to do this, and they don't do it like you see in the movies where they hold it gangster style. The idea is when they draw a firearm, it's put to work in the manner in which it's drawn, which is by grip. So could he have taken the gun up and angled his wrist this way? Anything is possible. That doesn't make it plausible.
Okay, well, tell me then. Tell me what's not plausible about this. If I'm laying down on the ground and somebody's over me at any angle, I can always make it 90 degrees, right? I mean, it can be 90 degrees here, it can be 90 degrees here, it can be 90 degrees here. It depends where the other person is, right?
Everything depends on where you are in relation to that other person. It also depends on where the firearm is in relation to that other person. When you talk about the discharge of a firearm, and you talk about, and if you've done any kind of shooting, if anybody's done any kind of shooting, you learn very rapidly that the wrist position is not exaggerated. Why? Because that's not how you shoot. It takes very much conscious thought to remove yourself to put it so that you're out of another position. Is it plausible? It's possible that the wrist was moving, and I'm not trying to say it's not possible, it's just highly unlikely.
So it's possible you can shoot somebody almost at any angle because we have arms and wrists and elbows, right?
Anything is possible, yes.
You were asked a question, I think, before the lunch break about, was it your opinion that George Zimmerman's perception of the threat had disappeared because Trayvon had run off? Is that what you said?
Make sure I was very clear on this. When I listened to the call and I heard Mr. Zimmerman mentioning Mr. Martin in the recording where he was facing him, my perception of that call at that time, I sensed stress in his voice about the fact he was approaching him, looking at him, his hands was going toward his waistline. As he left, that tension diminished. That, to me, also reinforced what I've already heard from Mr. Pollack and saw from, again, reviewing the information in this case. He's not the confrontational one. He's not that I'm going to get on you type. When Mr. Martin ran, is what basically he's running, there's no immediate threat to him. His perception is he's taken off running, so he gets out, and that's where he is now trailing or following, I would say following the person, to see where they went because that's what he was doing for them.
Well, didn't you hear the defendant say, I don't want to give up my phone number because I don't know where he is?
Yes.
Doesn't that indicate to you that he still might be a little concerned about what's going on?
Mr. Zimmerman?
Yes.
Oh, absolutely. But I mean, when we look at it that way also, when we're talking about timelines, if we're thinking about the T, and he took off running to make it home, it's my understanding home wasn't that great a distance away, considering his age. How come he wasn't able to make it the exact distance? If he's still in the area, it's presenting a concern for Mr. Zimmerman because he's lost complete sight of him. He's not running at the end of his distance, even though the visual acuity is minimal because of the darkness. So now you're looking at an individual that is walking back, and he's uncertain as to whether or not he's actually still there, so he doesn't want to give out his phone number.
Let me ask you one more question about the firearm. Were you aware that the defendant was trained by a federal marshal how to shoot?
Yes.
You also said that interviews, you feel like an interview is better if it's delayed.
Not all interviews. We were talking about the use of deadly force, and the comment was made to me about, for example, using references for law enforcement. It is a common practice to delay the interview because of the known memory loss issues and to extend the time before you conduct a thorough investigative interview of a police officer.
But that's not what you... Go ahead.
My interpretation when I was asked that question is it just seemed reasonable that if we extend that courtesy to law enforcement, it can be extended to anybody.
But that's not what you did as a police officer, right? I mean, when you arrested somebody, a suspect for a crime, you didn't wait a couple days to interview him, right? Didn't you interview him right there?
Of course not. Because the idea is, and I mean, to be very honest, when you're a police officer, you're told all the elements of the crime to the best of your knowledge. You're given the discretion to make a decision as to whether or not an arrest is warranted, and you base it off the facts that are known to you at the time. So when you ask for an interview and you're interviewing a bad guy, if it happens to be a homicide, which I have investigated homicides, if it happens to be a homicide, you're going to go in right away. And if the individual says, I want a lawyer, they're getting their period of time where they're not going to have to talk. That's their lawful right. The investigator doesn't wait. The investigator goes ahead in and tries to get whatever information he can, but he also uses the totality of the circumstances that he finds himself in so that he forms his questions and he makes a determination based on those interviews whether or not an arrest is warranted. But I wouldn't wait 3 days unless there's no rush to make the arrest.
And you're aware that the defendant spoke with his friend, the best friend that I've asked you about 8 hours after this event?
It's conceivable, yes.
And just to be sure, just to be certain, you're not an expert in memory retrieval. That's not what you're telling us.
Memory retrieval? No, sir.
Right.
No.
May I have just a moment, Your Honor? That's all I have, Your Honor. Thank you.
Thank you. Redirect.